Okay, good afternoon, everyone. Welcome to ISP's Virtual Bootcamp webinar. Today's topic is Contract Pitfalls, presented by Reid with Holmes, Murphy & Associates. My name's Ariana. I'll be the moderator today, so if you have any questions regarding today's webinar or our Virtual Bootcamp or any other of our education programs, please feel free to reach out to me. I just have a few quick announcements before we get started. First, the handouts for this presentation are available in the handout section of your taskbar, and of course also on the website. You can find the link to the quiz on the same web page. You should have the link to that web page from your confirmation email that was sent to you this morning. Please just be sure to complete the quiz by this Friday, and I can get you your PDA certificates as soon as possible. If you have a question for Reid at any time during the presentation, please type it in the questions box, which can be found on your taskbar, and I'll read those aloud as we go. I think that's all, so I'll hand it over to Reid.
Awesome. Thank you, Ariana, and as always, thank you for the opportunity. We always like to support our friends at the ISPE, and the boot camp is another time that we're able to do that, so we thank you for that. Joining me today, we have Leslie Babcock as well, so you get a double awesome dose of contract pitfall knowledge from Holmes, Murphy & Associates.
Good afternoon.
All right, so today, again, we're going to go through some of those contract pitfalls. I do encourage you to ask any questions as they come up. This is a presentation for you to give you more knowledge. So if you have questions as you go through, just let us know and we're happy to address those. That way you go away from this with more information, hopefully. So here we've got our, this is an AIA registered course, so we've got our AIA slides and then our copyright materials. We are members of the Professional Liability Agents Network, which is a network of professional liability insurance agents across the country, just like us, and this content was provided and registered by them. With that said, let's hit the learning objectives.
Okay, great. As you can follow along on the screen, today's learning objectives. At the end of the program, participants will be able to understand the exposure risks associated with different contract types, identify specific contract clauses which cause insurability concerns, identify specific contract clauses that help protect the design professional in contracts, and learn tools and techniques to modify these problems and negotiate an insurable contract agreement.
Awesome. Thank you, Leslie.
Yes.
All right. So today, contract review for smarties. So you see all those books in the bookstores,
For dummies.
Yeah, for dummies books or whatever, but we're not dummies, we're all smarties. So today we're doing contract reviews for smarties. A disclaimer, we are not attorneys. The following information is not intended as legal advice or a coverage opinion of your specific policy. As your insurance broker and risk manager, it's our goal to help you identify some of these potential wordings that may be uninsurable. So if you want real legal advice, we encourage you to contact an attorney.
With that said, Reid, some of the content that was developed in this program and some of the photos and references you'll see hopefully don't date us too much. Now, I know I'm a little older than you are, Reid, but I'm not sure about our audience. So we'll have to see if everybody can understand some of the references made throughout the program.
Sounds good. And I do understand all the references in the photos, so I'm proud to say that. So, not all contracts are created equally. There's all sorts of different types of agreements, the verbal agreements, letter agreements, purchase orders, professional association agreements, your cust agreements. The key is to have something in place, some type of agreement, some sort of verbiage, some sort of understanding. Verbal agreements are the least preferred from a risk management perspective. Continued use within your firm can lead to increased professional liability premiums, carriers that are unwilling to insure your firm because their view is that a contract, a written contract, is the first line of defense of risk management for your firm. If you're not willing to put up that type of agreement or something in writing, then a lot of them just have the philosophy or the underwriting approach that they don't want to work with your firm. Why are verbal contracts bad? As the old saying goes, they're as good as the paper that they're written on. There's no paper trail. A lot of times it's a he said, she said type scenario where if in the event that a dispute arises, well, you're supposed to do this and this and this. Well, no, that wasn't my understanding. So it's just good to put these things in writing and to have a firm understanding between you and your client. Secondly, moving forward with the letter agreements, the letter agreements are better to have in place. If you're using these type of agreements, that's great. We would just encourage you to spell out your scope of services very specifically, and at least include some some normal terms and conditions to help protect your firm. Purchase orders. Purchase orders tend to be not very favorable agreements for design professionals, simply because they're more meant for products or supplies or contractors, that type of thing. So we would encourage you, when possible, to try to keep away from using those. I'll also say, if you ever get a contract that's calling you and naming you as a contractor, generally that's a huge red flag, because most of the time we look at those and the rest of the contract is going to be a verb for a contractor who are swinging the hammers, providing actual construction services, and many of those contract clauses and whatnot will not be applicable to you and could put you in an uninsurable position. Going further down the list, professional association agreements. They're not 100% perfect, but they're a great place to start. You can certainly alter those a little bit for your needs. And then lastly, the custom agreements. Here, you're developing your own firm agreement, probably working with an attorney to do so. These are great. These are typically some of the best agreements out there, because you're able to put a lot of contractual items in there to protect your firm from your clients. So again, always encourage attorney assistance with regards to those. So when you can't use your agreement and your client comes back and they give you their agreement, be very cautious. Read the contract. It's amazing the number of people out there, and we're all guilty of it, that go through and we just sign contracts blindly. When we're agreeing to those software licenses on your computer, those are technically contracts, and we're clicking the box and we're hitting forward and completing those. Same thing when we're updating our phones with the latest software system, all that type of stuff. We're actually agreeing to contracts, just don't want to go through the 111 pages of verbiage with regard to those. But with these design services contracts, it's important, especially when it's your client's contract that they're pushing over the table to you. Open up that conversation with your client with regards to what's in it. It's really, at this point, it's a great opportunity to open dialogue about the expectations on the project, a good way to develop your scope of services, give them the opportunity to ask you questions. I've said it once, I've said it a million times. If you've ever heard me speak, you've heard me say, I believe one of the biggest challenges for design professionals is just informing people of what it is that you folks do, what it is that you provide, what it is that you don't provide. There's a lot of misconception around what it is that you do on a project. So when you're going through these contract negotiations, it's really a good time to bring up those kind of conversations, and it can help strengthen that bond, that relationship with your client as well. What does that language mean in their contracts? Is it better than standard form agreements? You've always got your AIA docs, your EJCDC docs, your standard firm agreements. You can kind of compare some of the language they're trying to use. Is it equivocally allocating the risk? Are there deal makers, deal breakers? Or is it a very one-sided contract that is really poorly in your favor? So take a step back. So many times our clients will send us contracts and say, hey, we got to have this right away. We need it signed. The bank needs this lender agreement signed. We've heard it all. Take 5 minutes. Sleep on it. If you don't understand it, don't sign it, period. So many times we'll get the excuses, oh, my lawyer said it had to be in the contract, or we're not going to enforce it. Don't worry. Everybody else is signing it. That's about the worst one, because chances are they're lying. It's wrong. Most of the time when you folks send us a contract and they said everyone else is signing it, we probably looked at the same contract last week, and a design firm similar to yours came back and said, we're not signing this. So don't fall for those. Just have the conversation, explain, work with your insurance agent or your attorney to kind of find those uninsurable items. When you're negotiating, try not to get to the junior person. The junior person most of the time will say, no, 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 they really don't have any authority. You really want to get up to actual decision maker. You have all sorts of resources with regards to comparing it against different contract documents again, and then sometimes your insurance carriers have a vested interest in your firm. They have contract guides, contract wording solutions, all that type of stuff. So wake up and smell the brimstone. So here's some overall warning signs about your potential client. If your initial contact with them is hellish, very difficult to work with, not getting great information, non-responsive, all that type of stuff, typically it's not going to get better as the project moves forward. This may be a red flag for you to step back and say, do I really want to work with this client? Is this a project that I really want to be a part of with them? A teeny tiny scope. Yeah, they've got a tiny scope because they don't have any money to pay. Be cautious with these. It needs to be built out. It needs to be very thorough. What your firm is doing, what another firm is doing, what the owner is supposed to be doing. You know, flesh all this information out very distinctly. The champagne taste and the Pabst Blue Ribbon beer budget. Yeah, they want lifestyles of the rich and the famous with Robin Leach, but they're getting some redneck PBR beer budget things going on here. So again, you know, when you're adding to scope, when you're budgeting, all this type of thing, there's a happy medium with regards to the timing and all this stuff. So have those conversations with the client, and you know, sometimes it's necessary to kind of put them back in perspective and say, I know this is what you want, but this is the actuality, what you can get based upon your budget. Fly now, pay later. If you decide to take this work on, it's likely that you may be paying for it later. So just be cautious. Uninsured problem number 1, increasing the standard of care.
So we're utilizing and referring to the Excel policy, which many of our insureds utilize. But again, the contract and coverage may be different, slightly different in your firm's carrier policy. So first of all, when we're talking about specific language, many of us kind of, how do I want to say it? We want to make sure that the information in the contract is insurable. And that's where we come in and say to you, we're reviewing this for insurability versus, you know, we're not your attorneys. So the first thing we want to make sure is that, okay, I don't know how to explain this, Reid. Give me some.
Sure. So you want to make sure that the contract is insurable. If it's not insurable, the policy is not going to pay in the event of a claim. So when it comes to the standard of care, that type of stuff, it's important to mention some of the specific exclusions in your policy. So this one is the contractual liability exclusion. The contractual liability exclusion basically says that you're only liable for what you would normally be liable as determined by a court of law in the absence of a contract. So what does that mean? It means if you're agreeing to outlandish or certain things or contractual things in your contract, your professional liability policy isn't going to pick that up. So kind of an outlandish example is maybe you agree contractually that you're going to provide cars for your client's employees if there's a design defect. Your professional liability policy is not going to pay for that. That's something you're agreeing to on your own. That's going to be coming out of your pocket. You just have to be very cautious about what you're agreeing to contractually. You can't agree to pay the party's prevailing attorney fees, that type of thing. There's these exclusions in your policy that you really have to watch out for.
And then I think the next thing is the trigger word of negligence, because in order for your professional liability policy to respond, it has to be tied to the negligence of your professional services. And that is what essentially triggers the policy to react.
Yeah, so here you've got Black's Law Dictionary, the definition of negligence, and they've got the court's definition of that structural engineer standard of care. So the degree of skill and learning ordinarily possessed and exercised by members of the profession in good standing in similar circumstances at the time of the alleged negligence. I'm sure you've heard this standard of care before. You're not insured for perfection. Your courts will determine your negligence via this definition of the standard of care. So kind of visually oriented here, again, the definition of the standard of care. Got your covered, which is covered just fine. If they want perfection, that's not going to be covered. So an insurable standard of care. Here's a great example. Manner and consistent degree of skill ordinarily exercised by a member of the same profession. An uninsurable standard, consultant warrants that to the owner that they're going to work shall be performed in accordance with the highest standard of care. It's going to be your trial exhibit number one there. That's the thing they're going to blow up when you're negotiating, or if it goes all the way to court. This is what is going to determine the court's actions or the mediator's actions. So, an example, several years ago, we had a structural engineer client in the Midwest. They're performing some services for condos for a developer. No red flags there. The developer insisted that they use their own contract, and they were unwilling to make any changes. The structural engineer desperately wanted the work, so they accepted the terms. The project proceeded and was completed without much fanfare or ado, but after a couple of years, some cracks started to appear in some of the condo walls. At this point, the contractor is out of business. They were a fly-by-night contractor. They were in business for a couple, 3 or 4 years, and then they exited. They went bankrupt. And the developers in poor financial condition or not existent, because many times these developers create these entities. They'll be called like 123 Main Street LLC, and then once 123 Main Street LLC Once that building is complete, they will disappear. So when the claim comes in, the structural engineer is the only one left standing. They're the ones stuck with the bill. So the structural engineer reports that issue to the insurance carrier, and they work on their behalf to settle the claim. But this clause specifically is encountered in that contract between the owner and the structural engineer. So it's a reputable insurance carrier. They do their best to pay everything that they can. However, at the end of the day, because this is a higher standard of care, the structural engineer actually ends up paying somewhere in the neighborhood of $200,000 or $300,000 out of their own pocket because the insurance carrier was unable to cover the entire claim because of this uninsurable language in it. Other uninsurable language include warranties and guarantees. Again, going back to that standard of care, these words such as warranties, guarantees, any, all, best, certified, complete, warranty, you know, all this stuff, highest standard of care. These are all words that have court-interpreted meanings, and those court-interpreted meanings make them a higher risk for your firm, and it raises your standard of care. So when you see these words, use caution and try to get them out of there, change them, run them by your attorney. You can share with your insurance agent from insurability's perspective, all that type of stuff. Just be cautious. The other thing we'll talk about here is the Batman rule. So this is kind of a funny one. So if you're reading through a contract and you see weird sounding phrases, or it's something that's kind of like the old Batman would say, not the Christian Bale Batman, not Michael Keaton. This is like the old school 1960s Adam West Batman. He used to have a pretty quaint way of speaking. He'd say, "I wish I could help you, citizen, but we're just a couple of ordinary crime fighters going about our mundane business." You couldn't just say, "Hey, we can't help you right now, we'll be right back." They'd always say something very scripted, very long and forthcoming. And it's kind of like, so what'd you just say?
Like hidden language, maybe involved.
Yeah. So if you're reviewing your contract and you can hear Adam West Batman in your head saying some of this stuff, again, seek help, or go back to your client and get more clarity, or whatever it may be, your insurance agent, your attorney, that type of stuff. So one of these is time is of the essence. This is some of that Batman language that we're talking about. So this seemingly innocuous phrase can do design professionals serious harm, especially if specific completion dates are stated in the agreement. In fact, it may be interpreted to mean that the professional services must be completed in strict accordance with the schedule. Even a minor delay could be cause for a client to terminate the contract and or make a claim for delay damages. Fuzzy language such as time is of the essence may also elevate the standard of care, which in turn can lead to insurance coverage issues. It could also generate claims even when the deviations from the client's unstated expectations are minor. You could be accused of breaching the contract, in which case the client might refuse to pay your fees, or you could be held liable for delays since you acknowledged the importance of time in your agreement. What's more, some professional liability insurance carriers do not cover claims arising from late delivery of drawings and specifications and reports, absent any allegation of negligence. Some do, some don't. You just have to check your policy language with regards to that. Holy products liability, Batman. All work specs shall be free from defects, conform to all respects, all specifications. You have to delete this. This isn't a product. Again, this is directly tying to your standard of care, and it's elevating it. Chances are, if you see this language, you're looking at a contract where they're referring to you as a contractor a lot, or it's a purchase order agreement, something like that. Again, You're not a product, you're providing professional design services. Contractors shall perform the work in compliance with any and all federal and state local laws. This is fine. We see this in a lot of contracts, but the bugaboo here is can you work in compliance with any and all federal, state, and local laws? What happens when they conflict with each other? What happens at that point? A lot of times what we'll do is we'll recommend that you insert some verbiage in here that says the consultant shall make reasonable professional efforts to comply with all federal, state, and local codes. And then if those codes conflict, then you're contacting your client, bringing it to their attention, working with the appropriate associations or governmental bodies to get clarity on some of those conflicts, or what you can do to help alleviate those. The engineer shall verify that the drawings and specs have been properly coordinated, and the mechanical, electrical, plumbing, fire have all been properly coordinated, and there are no conflicts anywhere. So again, yeah, right. This is more the onerous language, not in conflict anywhere. With so many different systems and so many different professionals involved with the work, it's pretty easy for systems and the designs to conflict with each other. Again, don't make promises in your contract that are unattainable. You're working with the design team, you're working with the owner, you're working with the contractor to find solutions. Design in nature is not a perfect thing. You have to work with everyone to make sure that it's meeting the client's solutions at the end of the day. Insurability problems, number 2, someone else's boo-boos. Indemnification clauses, if I can spit it out here. So indemnification clauses are the number 1 uninsurable items that we see in your contracts. And about 85% of the contracts reviewed, the indemnity will be uninsurable. When you see these clauses, find some resources to help you negotiate these, or run these by your attorneys, your insurance professionals, that type of thing. Responsibility for the contractor's work. It isn't your job to determine if the contractor's work is in strict compliance with the construction docs. You just determine if they're in general compliance. A lot of times you'll see that language coming from your bank or your lender or the owner saying, hey, you need to make sure that the contractor is doing their work, you're verifying their payments, all that type of stuff. Well, that's fine as long as you're doing this in general conformance. Responsibility for job site safety, exclude responsibility for job site safety. Be very clear about this. You don't want to have any responsibility for that. You're not really properly insured for that. That's the contractor's responsibility, the owner's responsibility. Yes, you're responsible for following job site safety measures as put forth by the contractor and the owner, but you're not responsible for going around on the project and making sure everyone's safe. Shop drawings, give some standard stamp language that you're using for the shop drawings for your approval. Something like the reviews is only for general conformance with the design concept. Kind of goes on like that. We're going to spend a little bit more time on each of these. The uninsurable indemnity. Here's a good example of an uninsurable indemnity. Engineer agrees to assume all risk of loss and defend, indemnify, hold clients, officers, directors, wholly or in part by any action. There's a lot in here that you really need to to fix. the trigger for your professional liability policy is an actual negligent act, error, or omission in the performance of professional services. In the absence of that trigger, there is an insurance coverage. So an example of that, there was many of you may have heard about that case in California some years ago where there's a structural engineer and they were working with an owner, and in the owner's agreement, it had an indemnity similar to this. And the owner had alleged a negligent act, error, or omission against the structural engineer. So it goes all the way to court, and the court makes a determination that the structural engineer's actions were not related to a negligent act, error, or omission. So there was no negligence on the part of the structural engineer. Well, that's great news. They didn't do anything wrong. Great to hear. However, they had this indemnity clause in there. And by agreeing to defend their client and include this language, they kind of canceled out their insurance coverage. So again, since there's no trigger for that negligent act, error, or omission, there's no trigger for the insurance coverage. The insurer would not pay for the defense costs of their client. So the engineer ultimately had to pay this out of their pocket. So these are the kind of the key things I look for in the indemnity clause. First, I want to get rid of that word defend. I want to make sure that you're only hold harmless and indemnifying to the extent caused by your negligent acts in the performance of professional services. That's the key. That's the trigger. So we saw example of a terrible indemnity. So here's an example of a good indemnity. You may wish to steal this and put it in your agreement. I don't know. Consultant agrees to indemnify to hold harmless. Again, getting rid of that word defend against damages, liability, and costs to the extent caused by a consultant's negligent performance of professional services. There's your trigger. Here's another one. This one, the architect, the engineer agrees to defend and indemnify and hold client harmless from any and all liabilities, damage, costs arising from any material breach of this agreement. This is pretty wide. And again, we've got that word defend in there. So this is one where we want to strike that word defend and go back and hold it just to the extent of your negligent acts, errors, and omissions in the performance of professional services. So you say permit, I say license. In this scenario, the contractor agrees to procure all permits and licenses necessary or required by any statute, ordinance, rule. So here they're calling you a contractor, so it's not a great clause anyway. But the intent seems innocent enough. But where the issue comes in is with the words obtain and all. The owner and only the owner bears the risk of whether or not his or her project receives the approvals from whatever regulatory bodies have jurisdiction over that project, whether it's city, county, whatever it may be. Architects and engineers often help their clients apply for those permits and approvals normally required for construction by assisting in completing the appropriate forms and providing the necessary data. But regardless of how much you help, you cannot promise to obtain something over which you have no control. The approval and permit procedures can be slow and sometimes pretty arbitrary, even from different personnel in that same department or that same entity. It's impossible to guarantee the action or the inaction of a governmental agency regarding the issuance of anything, besides maybe your tax bills. They'll always get those out in a timely way. But as for permits and stuff, there could be things beyond your control that you can't promise, you can't flat out say that you can for sure do that. So use caution there. You may want to include some language that says, hey, I'm going to assist the owner. I'm going to assist my client with doing with procuring these permits and whatnot. When it comes to safety, be cautious. Don't play the safety cop. Claims and the standard of care will follow your actions on a job site. Just because it's in the contract, that's good, but you also have to follow your contract and your scope of services by your actions on the job site. If you're out there citing OSHA and safety, you're increasing your standard of care just by virtue of your actions. If you see a situation that arises that poses an immediate and imminent danger, then certainly intercede. But if you notice a safety condition that may need attention, tell the construction foreman on the site and make a note that you informed the foreman in your notes, and then drop it. If it's a continual problem, inform the owner, whatever it may be. Be also cautious with your construction observation photos. In a lot of instances, design professionals will go out there and take these great panoramic pictures of the construction site. Be very specific in if you're observing connections, structural connections, weldings, bolts, rebar, that type of stuff. Be very specific with your pictures and just capture those areas. If you're doing these big panoramic pictures, a lot of times you may accidentally capture stuff that you didn't want to. Example that engineer was doing construction observations that had all these great photos. In the course of discovery, the opposing attorney gets copies of these photos and they blow them up, chalkboard, whiteboard size, and they put them in the courtroom and they point in the far corner of it. Said, hey, there's a safety issue here. Someone was hurt. You're liable for it because of this picture. You were aware of it, so you're liable. Well, no, you weren't, because you're just looking at one certain part of that picture. But they've blown it up in this courtroom setting, as they often do, and now you're going to be on the hook for some of that liability just because you accidentally captured that. So be very cautious. Put language in your contract specifically excluding safety. A lot of the AIA docs have some good verbiage with regard to that. Here's some from the AIA B101. The EJCDC documents also have some good language with regards to excluding safety. Jed, move away from there. Other tips and traps. Playing detective. So here, the consultant shall make a thorough inspection of the existing buildings and shall assure a proper correlation between new and existing work. So again, the statement seems pretty innocent, and it may seem natural to say, hey, yeah, we're going to make sure that the addition we designed works well with the existing building. But the pitfall here is that the inspection tends to be defined as perfection. So unless you're going through and counting every stud, brace, angle, piece of rebar, whatever it may be sure to delete this term. Unless you're there the entire process, you don't know what exactly lies underneath or beneath. Case in point, we had a claim here in the Midwest a few years ago involving sprinkler systems in a building. The design professional was including the plans for the implementation of the fire sprinkler system, but the contractor wasn't actually putting the piping under the ceiling tiles. They were just putting the sprinkler heads on and calling it done. If there was any inspection language included in this case, the designer would have been up the river a little bit. They would have been on the hook for that liability. Again, your job as a design professional is to provide the design documents. And just assure general assurance, general conformity. with those documents. Got Dr. Evil. All design drawings and specifications created under this agreement are considered the works made for hire and of the property owner. The ownership of documents. We see this more and more in contracts we're reviewing, and it seems to be kind of a losing battle for design professionals. Your clients are expecting some sort of work product for their money. They want something tangible. They want something in their hot little hand. So they're kind of wanting the ownership of the documents. From a risk management perspective, we encourage you not to give up the ownership, but we're seeing this more and more. So what can you do? If your client is insisting upon ownership, include some sort of indemnity or hold harmless language to protect your firm. What happens if your client decides to build a similar building or structure? They have some plans right there they can use, right? If they move forward with a project without your knowledge or consent, since your name is stamped on those drawings, on those plans, you can be on the hook. So include some language that states that any unauthorized use or reuse of the docs aren't your responsibility and you're held harmless from such use. Here's a poor example of what that is trying to accomplish. While this kind of looks like a hold harmless or an indemnity clause, it's really not. You really need something a little more ironclad. So we encourage you to work with an attorney. A lot of insurance carriers have some sample language. If anyone out there needs a little bit of sample language, please let us know, and we're happy to send you some. Top secret plans, confidentiality. So you might see some sort of clause like this in your contract with the client, but this could certainly create a conflict between your contractual obligations to the client and certain laws and regulations. For instance, if you obey the law by reporting to appropriate agencies discovery of hazardous materials, you may be breaching your contract with your client. But if you abide by the contract and don't report your findings, you may be violating the law. So your professional duty to protect the public health and safety goes beyond the duty owed to that client. But you could be held in breach of contract if that confidentiality clause is too onerous, too stiff. So if your client insists on some confidential wording, you need to be clear on certain points, such as your obligation to meet government requirements and your rights regarding sharing information with employees, subconsultants, legal counsel, responding to subpoenas. It's also important to insist that the client identify any information to be confidential. Is everything related to that project confidential? Can you not talk about anything or disclose anything? A lot of the times these clauses are very broad and not very specific as to what they may be really trying to protect the confidentiality of. Yes, Judge Waffner, got the owner's court. This is always a fun clause we see. The owner may make deductions from the architect's compensation on account of changes in the work incurred by the owner resulting from the negligence, act, errors, or omissions of the architect. So here the owner is the judge and the jury. They get to make all the determinations about what you're doing wrong and what they're going to pay you. Strike this language, get this language out of there. The owner, in its sole discretion, may elect to subject disputes arising out of this agreement to resolution by arbitration or litigation. So here we're starting to look at some of that dispute resolution language. Of course, the time to negotiate any of this dispute resolution language is before the project starts, not when an issue arises. Be cautious about what methods you're using, what language you're using, and be sure to actually include this. This is a deal maker. If you're not seeing any dispute resolution wording in there, it could break the deal. set out the dispute path. Important insurance stuff your clients and their lawyers don't know. So you have a claims-made policy. With regards to your professional liability policy, it's a claims-made policy. This means in order to have coverage, you must continually renew that coverage. And if you cease that coverage, you won't have any coverage for any project that you've ever done. So the example I always use of that is a new engineer calls me up and says, "Hey, Reid, I need some insurance for my professional services." I say, "Okay, we'll get a policy in place for you today." So they purchase the policy, they perform some projects, things are going well. 3 or 4 years later, they call me and say, "Hey, Reid, you know, I've got an opportunity to go teach at the university. So I'm going to cancel my insurance and I'm not going to perform any more professional services under my design firm." I said, that's fine, but be aware that when you cancel this now, anything that you've done in the past is not going to be covered anymore. So again, it's very important to understand that claims-made coverage, that you have to have insurance in place when that claim is made. Just a couple notes on certificates of insurance. A certificate of insurance is simply a statement in time that insurance coverage exists. It's not a legal document. The policies, your policy contracts can be legal documents. A certificate of insurance is just basically an exhibit showing, hey, I've got insurance at this very moment. There's certain things you can't say on those certificates of insurance with regards to professional liability policies. As insurance professionals, we can only put statements on those certificates of insurance that are true. So when it comes to some honors language that they want to stick on those certificates of insurance, sometimes we have to be very cautious about what wording we're including on there. One of those is additional insured for professional liability policy. While this is very normal for general liability, auto liability policies, umbrella liability policies, it's not for professional liability. The way that policy is designed to protect you and the exclusions in the policy make naming them as additional insured on the professional liability not possible. And it could actually void your coverage. So what's missing? Too many notes, Mozart. The AE shall process, review, approve, return shop drawings, product data samples, substitutions. Again, this is very vague. You have to approve it. Why don't we nail it down a little bit? Why don't we get information from the contractor, approval from the owner, that type of stuff. With regards to your shop drawing language, EJCDC and the AIA B104, they offer some pretty decent language. I think one of our carriers has some pretty decent language as well. We encourage you to have some sort of shop drawing stamp language in place. What can you rely on? You, as the design professional providing services, should be able to reasonably rely on the information provided by the owner. A lot of times you'll see this language in the contracts where it says, hey, design professional may reasonably rely on the information provided by owner with regards to if there's a survey, if there's a geotechnical report, these type of things. If they're giving you the information, you should be able to rely on those. So try to include some language. Here's an excerpt from the AIA docs. It's pretty good. Don't forget the general, George C. Scather. With regards to construction observations, we see a lot of claims that arise in regards to a lack of construction observation. We know that many owners are on a tight budget. From the claims we see, if you're able to complete some basic construction observation services, it puts you in a better risk management position. I know for a lot of tollway projects and state projects, capital development board projects, that type of thing, that they hire those construction observation services out separately, but to a different firm. But if you're able to provide any of those services, or at least make sure some firm is providing those services, it's better risk management for all parties involved. So you got the hokey pokey, you put the good stuff in, take the bad stuff out. That's what it's all about. Your scope of services, again, be very specific about what it is that you're doing, what it is that you're not doing, what others are doing. Make sure it's the contractor's responsibility to follow the plans. Well, that's always nice. You're creating these design documents. It's nice when they actually follow them. Make sure the contractor or the owner is solely responsible for the safety. Construction observation clauses. If you're not providing it, you can put some sort of indemnity clauses in there to protect your firm. You want to make sure you're including some sort of clause that you can quit if you're not paid. And again, that right to rely on information. Dispute resolution. Mediation is the preferred first step with regards to those dispute resolution methods. Mediation, then litigation. Arbitration isn't really preferred by attorney counsel and carriers of design professionals, just because it's shown that it hasn't been a very successful dispute resolution process for design professionals. They prefer the mediation than the litigation. Puts you in a better position. Again, the document ownership, keep ownership if you can, get some hold harmless information. Be very clear that you're not responsible for hazardous materials. Put some sort of language in there. Again, here's some AIA language they can stick in there. That's a pretty good example. That way you're not responsible for some of those hazardous materials. We talked about mediation. Mediation is certainly a little bit better than arbitration. The reason why: mediation is non-binding. The mediator usually is a little bit fair. And if there's no decision, then you can move on. With regards to arbitration, it's binding. It's very hard to appeal. It's almost impossible to appeal. The arbitrator just makes a decision. There's not a required set of evidence that they're required to follow with regards to making those decisions. So if they wake up today and they say, hey, the design professional's going to be wrong all day today, technically they can do that. Again, can't be appealed except in very rare circumstances. Lastly, if you can include some sort of limitation of liability, try to include it. Obviously, a lot of state and governmental bodies won't accept those, but if you're able to put in any sort of limit, any limit is better than unlimited liability. So if you're doing a $2 million project and your fees are $20,000, why do you need to be on hook for the full $2 million? You know, try to include some of this language if you can. Any questions?
So it looks like we don't have any questions right now, but how about we give it a few seconds in case anyone has anything to type in.
Okay. Well, yeah, again, this has been Reid Just and Leslie Babcock of Holmes, Murphy & Associates. If you have any questions or any specific issues that you'd like to work through or have like to discuss further, just let us know. We're happy to help.
Okay, it looks like we don't have any questions at this time, but like they said, if anyone does have questions later on, feel free to reach out. I just have a few quick announcements. So just a reminder, you can find the link to the quiz in your confirmation email. Just be sure to complete that by this Friday. I'll send I'll email PDA certificates out on Friday as well. So thank you, Reid and Leslie, for a great presentation. Thank you, everyone who joined us today and throughout this web series. This is the last webinar for our virtual boot camp, so I hope that everyone got some value out of it. Since this is the first time we've done something like this, if you have any comments or feedback for us, we'd love to hear it. I also want to remind everyone that our virtual bootcamp webinars are available for purchase on our website. So if you missed a week or if you want to get a jump start on your hours for the next renewal period, please go check that out. It's on our on-demand webinars page. Looks like no questions have come through. So that's all I have. Thank you again, Reid and Leslie, and thank you, everyone. Have a great rest of your week.
Thanks.
Thank you. Bye-bye.